Thank you, Your Honor. I thought I'd start out by talking about what we're asking the court to do in this case. It seems like a good first point, and I'm going to do that in just 1 second, but I want to make sure, just in the way of background, the case, of course, does involve the City of Austin's proposed new land development code, comprehensive zoning statute. There's a lot of substance to that code, and this lawsuit is not really directly concerned with that substance. It's concerned with the procedures by which the city is attempting to promulgate the new land development code. Still, it's worth a minute to mention, just so it's on the record and the court knows. The overall purpose of the new code is to provide for more density in the city of Austin than I guess currently exists under the current code. And it involves, I guess, one of the most contentious issues is the issue of transition zones, which are zones of residential that consist of residential neighborhoods that are near major thoroughfares, as I understand it, in which the zoning will be changed to allow for significantly increased density in those neighborhoods. As you might imagine, that has caused a whole lot of consternation among the population. I am sure reasonable people can differ about the merits of the land development code. That's not our issue today, but it has spawned, I think, a pretty large number of organizations that have signed on to amicus curiae briefs that the court has, and I will certainly commend our amicus briefs for the court's attention. I think that they're very well done, and they're done on behalf of the Austin Neighborhood Council, which is an association of 80 different neighborhood associations within the city of Austin. The NAACP, with whom we're all familiar, they're concerned with the issue of gentrification. Bipolar, which is an East Austin social justice organization led by women of color, and by Development Not Displacement, which represents, according to the brief, represents vulnerable neighborhood versus secondary gentrification and displacement of low income and communities of color. So there's a lot of debate about the merits, even though many, if not nearly all, if not all of our plaintiffs may be against the merits of the plan or various aspects of it. That's not what has motivated this lawsuit. It's the procedures adopted by the city. And what we're asking the court to do, I told you I'd get back to it eventually, is we want them to start over. There's a notice issue here and a protest issue. They're separate issues, and those have been violated by the city. We think the law is clear, and so the only way that it can be done right is for the city to start over, give the individual notice that's required under the local government code, and to honor the protest, we'll be asking for a declaratory judgment that the city has to start over, that it must honor the protest, and at a minimum, if the court can finagle a way where they don't have to start over, under the local government code, which we'll get to in more detail in a minute, that they have to honor the requirement of a 3/4 supermajority vote in the city council in order to pass the revised land development code. That's what the government code says. It says that if there are protests, that then the governing body of the municipality, the city council here, must pass it by a 3/4 supermajority vote. And we want the court to declare that that portion of the statute is applicable. The 3/4 vote would be out of 11 city council members. To get to 3/4, they have to have 9 votes. And so, at the very least, that should be their burden. In the end, if they have 9 votes, then procedurally, we're cooked. The plaintiffs are cooked. There's no way around that. Once, even if protests are recognized, if they have a 3/4 vote, then that they can override the protests, I guess is the way to put it, and go ahead and enact it. But that's what we want to put them to.
Let me just ask you about two things that I was focusing on. One is this issue of ripeness, and it seems the city has voted twice, but there's a third vote that hasn't taken place yet. Do you know whether or not and when that vote may be scheduled?
I understand it's scheduled for late March or early April. Ms. Weber may have more first-hand knowledge. I don't talk to her clients, she does, about that, but that's my understanding.
Do you believe that this issue is right before that vote is taken?
Yes, I do.
And why is it?
Well, for a number of reasons. First of all, the violations have already occurred. Harm has already been done. The city has refused to entertain protests, and they're very much on record with that. In fact, on the stipulations of fact, starting with about, I think, 35 on the stipulated facts, we have memoranda from Assistant City Attorney Brent Lloyd. Zoning protests may not be used for this. We have a May 2nd memorandum and a May 14th memorandum from another person in the city's law department, Mitzi Cotton, to the same effect. Then we have an October stipulation of fact 38, in October 24th, 2019 email to the mayor, mayor pro tem, council members, etc., which forwarded the May 14 memo and stated that zoning protests may not be used to trigger a supermajority vote on broad legislative amendments, including comprehensive revisions, which is dead wrong under the law. So the city is, well, and in fact, on the city's website, it's another thing we complain about, they have specifically in their question and answer portion of it posed the question, as a property owner, may I file a protest to the zoning changes being proposed under the Land Development Code? City's answer on the website, no, zoning protests may not be used to protest broad legislative amendments. Again, we think it's dead wrong. So there's been a chilling effect already. That harm has been done. And so we think the court needs to redress that harm and needs to redress it now with declaratory judgment that establishes the rights of the parties. And also, since the court is, I'm not surprised, obviously concerned with this issue, I will, with leave of court, file a brief after this trial that addresses that issue alone, I guess, or along with maybe any others that the court may express concern about. But I have found out, been practicing law a long time now, maybe way too long, some people have stayed, including my family. However, I've learned more about ripeness than I knew since this, in recent days in this court, where, and when Ms. Weber brought it up, particularly in her brief, very briefly as an introduction, I'm sure you saw that. And the ripeness issue is a lot more complicated than I realized. We have, and I'll save 95% of this for the brief, but there's a Supreme Court case, Abbott Labs, and there's a Texas Supreme Court case, Perry versus Del Rio, which sets up a whole test for ripeness. Texas Supreme Court has quoted with approval Professor Charles Allen Wright's description of how things should be. It's a functional approach. Supreme Court, both Supreme Courts, U.S. and Texas, have endorsed that, and it's more complicated than that. There's the functional approach concerns the extent of the injury or the risk is first. And I noticed there's already injury for failure to give notice. The Planning Commission issue is ripe now because the Planning Commission did not send out notice as it should have under the local government code. When that happens, it's jurisdictional under the statute for the city council to even consider it. And they didn't send out individual notice. So that harm is there. The courts also talk about if there's a need for specific factual illumination. There's not in this case. We've got all stipulated facts in this case, so it's not like the facts are going to change. The city council's on record. There have been, in the first two readings, and this is of course in the brief, some city council members filed motions to honor protest rights. Another motion to wait until the court's ruling determined the issue, the legal issue of protest rights and notice. And both of those motions were defeated in city council by a 7-4 vote. And also there are issues of judicial economy and efficiency. This is a case where nothing is going to change between now and third reading. And you might wonder, how could plaintiffs in a case of this importance file a lawsuit on December the 12th and get to trial on March the 9th or March the 11th, as it turns out? Answer is, we couldn't unless the city wanted to go to trial too. And I believe, by the fact that we have all these joint stipulations, we have agreed exhibits, Ms. Weber and I have worked together to prepare this case in a way that would be efficient and would be quick. And I am not speaking for the city, but I'm just saying that to me, that could not have happened unless the city recognizes it's in its interest too to get an answer to these questions and to get one as soon as possible. And I think
I'll add that our central docket makes it possible as well. And if you had been in Houston or a city where there are individual dockets, you might have had to wait years. But here, cases do go to trial quickly. Let me ask you about the other thing that I focused on in reviewing all of the pleadings, and that is this issue of alternative notice. If the city and the zoning commission had had a joint meeting, they could have done notice by publication. And so you're asking that they go back and start over, and I'm just wondering if you agree that that was an option and could be an option.
absolutely. Section 21107D, I believe, of the local government code, city council by a 2/3 vote, I think it said, could, well, we already have a planning commission, the city council could direct that there be a joint meeting. And that would have been a different method of proceeding. And that would have done away with the need for individualized notice, would have allowed for public notice in the newspaper. Would not have done away, however, with protest. One fundamental flaw, I think, in the defendant's briefing is they seem to clump protest and notice together, as though if you don't have notice, you don't have protest. That's not correct under the law. So the protest issue would remain. The 3/4 supermajority vote requirement would remain. But yes, ma'am, that's why our brief says, this, one of the arguments the city makes is, we can't do this because it's too hard. Well, number one, not too hard. It's not too hard to give individual notice if they needed to. The city, and we discussed this in our brief, has on several occasions in the stipulated facts, there are 5 or 6 situations where there was rezoning not of the entire city, but of large areas of the city, many hundreds of acres in some cases. And individual notice was given in those cases, and protests were honored in those cases. How'd they do it? They used utility bills and sent out notices to everyone. It was not impossible. It could be done. And secondly, if they didn't want to do that, they can use the procedures you just alluded to, which is a joint meeting of the planning commission and the city council. It solves the notice problem, but the individual notice problem, but does not solve the protest problem. Still would require a supermajority vote. They'd have a choice. So if they have to start over, there's not that long a delay involved either way. I mean, they have to have 3 readings. But you know what? As I understand the way the ordinance works with the city, they don't have to have 3 separate readings. They could do 3 readings on one occasion, if I'm not mistaken. Or even if they decide to have 3 separate readings and we're sending out individual notice, there's not a long period of time in the statute that's required between the notice and the meetings. So in 3 months, could they do the whole thing starting over again? I think so. I don't see why not under the deadlines that are set out in the government code. Or if they did it with a joint meeting with the zoning commission and the city council, to do it that quicker, in my opinion. So, I guess before I go any farther, we don't know how many protests have been filed with the city. The city doesn't recognize them. There's some issues to whether they'll even accept them. However, there is one website, it's called Community Not Commodity, that had a link to file a petition, and we know that well over 14,000 protests were filed just through that website. This box, Plaintiffs Exhibit 1, I think our only numbered exhibit, contains copies of those 14,000 plus protests, which if you wonder like I did how you get 14,000 protests in that little box, to save money, they're printed forward to front and forward to back of the page, and there's over 14,000. I'm going to ask that Plaintiffs Exhibit 1 be introduced into evidence.
All right, is it already part of the record? That is it, was it included in what y'all filed? I see a notice of filing trial exhibits.
It's the only thing we have that has not been electronically filed.
So, any objection to Plaintiffs
No,
Exhibit
Your
1?
Honor.
All right, then Plaintiffs Exhibit 1 is adjourned. So we should hand that to the court reporter before we forget, so she can.
Even if she doesn't want it.
That's what she wants.
All right. We talk a little bit about the law here, a little more about the law. The leading case in Texas, I think, is the Bolton case, referred to in both briefs, Texas Supreme Court 1962. Supreme Court said, talking about the local government code, which is section 211 of the local government code under Title VII, and the statute, of course, is you have before you in briefs, it's an appendix or an attachment to our petition and so on. And the whole thing is only this long, and we're really only talking about 3 or 4 sections of it. So it's not that it's lengthy, and I guess you could say there's clearer statutes, but not a whole lot. The legislature, we think, did pretty well in this one in laying it out. It's been around a long time. We started with national model zoning codes in 1927 that many of the states, including Texas, adopted. And many portions of this statute have been around for that long. And Bolton has said that each act required under Chapter 211 is essential to the exercise of jurisdiction by the City Council. Each must be rigidly performed. So all these requirements have to be strictly construed and applied to the city in every detail. There's no variation allowed from them. The Supreme Court also said that the regulations are intended for the protection of the property owner and are his safeguards against the exercise of arbitrary power. So let's start. If we have the government code, and you may have it in several places in front of you, but it's also an attachment in the book, the notebook I gave you, the bound one. It's an attachment to the petition. And let's look at the first really relevant section, 211.002. Adoption of regulation or boundary includes amendment or other change. And it says, one sentence, a reference in this subchapter to the adoption of a zoning regulation or a zoning district boundary includes the amendment, repeal, or other change of a regulation or boundary. Amendment, repeal, or other change of a regulation or boundary. It's the city's position that, because it has to be in order for them to prevail in this case, that what they have done is not the amendment, repeal, or other change of the regulation or boundary. They've just substituted an entire new code for the old one, and that's something different. By illustration, I'm told that the city of Houston doesn't have zoning regulations, or of course many Texas cities don't have them. If a city wants to adopt zoning regulations for the first time, when before there were none, this statute would not apply, because they wouldn't be amending, repealing, or changing anything. It would be new. So how does the city fit their square peg into this round hole? They do it, and this is from their brief, they use various terms. They say that that comprehensive rezoning is akin to new zoning. It's akin to new zoning. Well, I think a human being, let's say I may be akin to a gorilla. Some people say disturbingly akin, but I'm not a gorilla. They also say that the comprehensive zoning is similar to new zoning. It's in their brief. Well, I guess it is similar in some ways, but it's not the same. They also say that new zoning is analogous to comprehensive zoning. Well, that it may be analogous in some way, but it's not the same thing. And the Texas Supreme Court says that you have to follow the statute, and you have to follow the plain language of the statute. And there is no exemption in the statute for comprehensive zoning. In fact, comprehensive zoning involves, first of all, you can't have two zoning codes. You can only have one. So if you're going to adopt a comprehensive new one that replaces the old one, you got to repeal the old one. You may pass an ordinance that says it's repealed, but you don't have to. It would be repealed by implication if it were replaced. Just like if the legislature passed a new murder statute that replaced the old, it would be repealing it. And other change of a regulation or boundary, I just don't see how they can really credibly argue that the new code does not change any regulations or boundaries. So it is, the comprehensive new code is covered by the statute. You know, the city has passed an ordinance. It's section 25-2-241, distinction between zoning and rezoning. And this, the cities do this to complement state law. They can't change state law. They can't detract from state law, but of course they can add to it, add to its requirements if they want to. So in the city ordinance, they say zoning is the initial classification of property, part one. Part two, rezoning amends the zoning map to change the base district classification of property that was previously zoned. Rezoning under their own city ordinance, just like it is under state law. And when that happens, then the local government code applies, because the comprehensive zoning, just like the old zoning, deals with everything. The next section of the government code, 211.003, talks about zoning regulations and talks about how they regulate the height, number of stories, size of buildings, percentage of the lot may be occupied, size of yards, courts, population density, and on and on. And that's what the new code does. And that's what the new proposed code does and what it contains. Okay, so then we move to section 211.006, which are the procedures they must use. And they talk about no regulation or boundary change is effective until after a public hearing, before the 15th day. Before the hearing, notice, there must be notice. And then it talks about in subsection C that they may prescribe the type of notice. The state law is very general as far as the type of notice. The cities have a lot of leeway. And I think a notice that simply informed the individual property owner that there is rezoning being proposed for your property. Go to this website, go to this link, here it is. And zoning and within 200 feet of your property, that's what section is applicable to. And then it talks about protests. If there are protests, the city must allow protests, and if there are protests, then there is a requirement in subsection F of a 3/4 supermajority. The next section talks about the zoning commission, and when you get down to D, which we've already talked about, talks about how they can use that method to be excused from the requirement of individual notice. Subsection D says if notice requirements are prescribed under this subsection, the notice requirements prescribed by subsections B and C and by section 21106A do not apply. Those are the ones that we referred to a moment ago. So and I think here's a point that I want to emphasize. The state legislature added this subsection D that we've talked about several times now in an amendment in 1985. They provided, and I suppose, well, I guess I could speculate, don't really know, that some cities complained about individual notice. So the legislature gave them a way around individual notice, this joint meeting. But in that same session of the legislature that added this subsection, they changed not one word of the language about protests, not one word about the requirement that if there are protests, it requires a 3/4 supermajority of the city council or other municipal governing entity in order to pass it. That all stayed the same. So if you're going to talk about legislative intent, there it is in its purest form, one of its purest forms, that they changed part of a statute but did not change the remainder. To us, that is an indication that the legislature didn't want to change anything else in the statute. So the protest law has to stay exactly the same. There is no Texas case directly on point on this issue. I don't think either side claims that there is. There are some cases in other jurisdictions, and they're in our brief, and they come out, guess what, on our side. That's why they're in our brief, hopefully. The first one is from New Jersey, Levin versus Parsippany, comprehensive rezoning case. And the appellate court, it was a comprehensive rezoning where the, what is this, village of Parsippany, made many of the same arguments that the city's making now. Oh, we can't do this, it's too hard, it doesn't apply to comprehensive zoning. And the New Jersey statute was identical in all material respects to the Texas statute. That happened not out of an accident, but because, as I mentioned before, way back in 1927, when all this got started, there were these model statutes out here that the states adopted. So they had a similar statute, and we refer to it in our brief at pages 14 and 15. The appellate court agreed with the city and said, we cannot conceive that the legislature would fetter the attempts of the city to comply with these ordinances by subordinating proposed ordinances to the right of protest by dissatisfied property owners and the necessity for a 2/3 majority vote. We have a 3/4 requirement, they had a 2/3 in New Jersey. Can't conceive of it. The case went to the New Jersey Supreme Court. They said, well, we can conceive of it. The legislature did exactly that. They're protecting property owners' rights. And so it doesn't matter if it's too hard. If there are protests, then you have to have the supermajority that's required under the statute. They said, the protest provision, which follows immediately after the zoning power provision in the new law, expressly applies to any amendment or revision of a zoning ordinance. Absent a specific indication in the statute that it does not apply in certain circumstances, of which we find none, its plain meaning indicates that it does apply. You could write that sentence in this case. The legislature in the local government code doesn't create any exemption for comprehensive zoning. The city's own ordinance that I read a few minutes ago doesn't provide for any exception. Therefore, there is none. We cite the Campbell case from New Jersey, which points out that protest and personal notice rights are independent. Change one doesn't necessarily change the other. That case notices that the legislature that still were in New Jersey did not change the protest language in 1995 when it amended the statute. It simply appended an additional notice requirement in the beginning of the statute. And they said, therefore, they didn't change it. The right to protest has enjoyed long-standing historical support in this state and other jurisdictions. I think they said for 50 years or something. Well, in Texas, it's been almost 100 years. That's long enough that it should not lightly be ignored or rejected. We also cite a New York case, 208 East 30th Street, which refers to, has similar language that the court said by reading the plain language requires protest. So therefore we must have them. The city cites a number of cases as well, of course. These are the, I have to say, for many months now, the city has been saying that it has substantial authorities, that it can do what it has done legally. And there have been requests for them to reveal those authorities to us. In fact, back in November, part of the record is a letter that I wrote to the city and said, well, there's got a lot of people out here that would like to see these substantial authorities. Got no response. Well, we saw them for the first time last Thursday. And I'm not complaining about Ms. Weber in any way. I'm just saying that's when, how we work things out. We got their brief and we saw them. And I have to say, with regard to these authorities, in the first place, not one of them is a protest case. They're all notice cases. Cases that talk about whether a city had to give notice under various, individual notice under various circumstances, which we've already talked about. We concede that sometimes they do, and sometimes they don't. But that's all that they are, not one protest case. There is the main one they cite is the Frisco case. Court of Appeals Fort Worth, and the Frisco case is not really a zoning case at all. It involved a regulation of the Texas Alcoholic Beverage Commission about how close liquor stores could be to schools. And they passed a citywide ordinance because I think required by the Alcoholic Beverage Commission that you couldn't sell beer, in that case, whatever, within 300 feet of the school. It was not a rezoning of any particular property at all. And if you read the holding of the case, which appears at page 264, this is, I think it's fair to say, their main case. We conclude and hold that the city's interpretation is correct. Additional notice to individual property owners under section 21107C is not required in a case such as this one. So that was the notice issue. And a case such as this one, in which a zoning ordinance change applies district-wide or across multiple districts without a change in classification of the individual owner's properties. Okay. No property was rezoned. There was a citywide requirement that applied across the board. So the city did not have to, this change was accepted and upheld because there was no change in classification of the individual owner's properties. Now, let me jump to, that is not the case here. What we have is huge changes in the plaintiffs and in thousands, hundreds of thousands of city residents' zoning. For example, our lead plaintiff, Frances Acuna, her home property is being rezoned from SF3NP to R2A. The city calls that comparably equivalent zoning. We can get back to that in a second. Under her current zoning, 12 to 15 units can be built per acre. And the new code will more than double the property's density and floor area ratio. How is that comparably equivalent zoning?
And I think this is in your reply brief.
Yes, ma'am. It is. Oh, that's correct. Then we have one other, plaintiff Mary Engel. Her homestead is being rezoned from SF3NP to RM1. Her property's units per acre, which to me in a way is maybe the single most important part of the zoning. How many dwelling units can you have on your property? Can you convert a residential neighborhood to a high-rise condo or to a two-story duplex or a four-story fourplex or whatever? Her property zoning would increase from 12 to 15 units to acre to 87 units per acre. Obviously, that neighborhood is being wiped out as far as being the quiet residential neighborhood that it was. It's not comparable zoning. And here is, this is Appendix 2 to the reply brief. And if I can put one before you. It's already in the book.
I have it, I just don't have it in color. I printed it out, it's grayscale. All right, thank you.
And what this exhibit shows, just for a moment here, and there's one in much more detail from the page before, but this is good enough for right now. You see that there's a chart, and it shows the current zoning in gray, the proposed zoning in, what color is that? Beige. Okay.
Orange, but whatever.
See? Good. All right. So if you were zoned SF1 over here, or SF2 or SF3, you see that you can go a number of places here, but you're going to end up with R2A, which is its own units per acre, substantially more. And then after 15 years, that's going to be even substantially more. SF4A, units per acre, is going from maybe 15 to R2C, which is going to be 30. And after 15 years, almost 40. SF5, single family 5, is going from about 18 units per acre to R4, which is going to be more like 70. And then SF6 has the most dramatic change of all. From under 18 to almost 90, roughly 5 times as many housing units on an acre as is now allowed. If you look at page 1 of that appendix, you see other factors in much more detail. This is what the city calls comparably equivalent zoning. How can it be comparably equivalent? They call it that because they have to. If it isn't, they can't get around these statutes. They could be within the Frisco case if all it was a, well, they'd be within the Frisco case, and they'd be within another case that they cite, which is the Tillery case from Arkansas on their brief at page 16, in which what the city did was upheld, and the Arkansas court said if they had that, they could win this case. But they don't have that. They have these charts. And these charts come directly from agreed exhibits, which is the old and the new zoning code. So, I won't go through all the remaining few cases. That's actually 2 or 3, and there's 2 or 3 more. All of them have flaws. None of them are notice cases. Some of them you can't tell what the statute is not provided under which the regulation was given. These cases do not help the city. These cases defeat them. So I guess I'll conclude with this. What we want, again, is we want the city to start over. If they do start over and they give notice, individual notice, and go that way, which is the way they've gone before, then we really think that that is what should be required for the citizens, property owners of Austin, because everybody should have a fair chance to participate. And when the city is on its website saying you can't participate and you can't file a protest, that discourages people. I assume that's why they put it up, was to discourage people, so they wouldn't have to deal with it. So everyone should have a fair chance. They shouldn't be allowed to get away with this chilling effect on citizens filing protests. And also, at a minimum, regardless of the court's holding on notice, Exhibit 1, we don't know how many protests there were. We know there's over 14,000. They have to honor those under the local government code, and therefore be required to have a 3/4 supermajority as the local government code requires in order to pass this. As I said before, if they got 9 votes, ultimately this is going nowhere. But that's the rules that the legislature laid down. And if that's not going to, if the city doesn't want that applied, it needs to go to the legislature and get that changed. But that's the protection the state legislature put on the city to protect its citizens, and it must be honored. We think that the defendant's argument in this case does violence to the language of the statute, misstates the holdings of the cases, both theirs and ours, creates a whole lot of rabbit trails through the woods, is what I call them, on what much of the evidence is totally irrelevant to the legal issues. They say it's too hard. We say it's not too hard. And if it is too hard, it's their fault. They made it harder than it needed to be. So let's start over and do it right. Thank you.
The precise legal issue for this court is whether the individual notice and the individual written notice and protest provisions of Chapter 211 of the Texas Local Government Code apply to the city's current revision of its land development code. And that issue depends a great deal on what the land development code revision actually does. So I'd like to start there on what is the LDC revision. It is a comprehensive revision of the city's land development code, which is currently chapter 25, title 25 of the city code. The LDC revision process is going to adopt a new title 23, and one piece of title 23 will be a new zoning code. The zoning code is only one chapter. It's chapter 23.3 out of 12 chapters. I've got here, just so you can eyeball it, these two notebooks together are the October 4th draft version of the LDC revision, and only one of these chapters is the new zoning code. It's the largest chapter, but it is only one piece of it.
It's the one that people refer to as what, 1,300 pages long or something like that.
Well, I think the whole entire LDC revision, the whole entire Title 23 is the 1,300 something, over 1,000 pages, but the zoning piece is in the few hundreds of pages of that. It's a subset of that. The zoning code is not over 1,000 pages just in itself. Now, our existing land development code, the city's existing land development code was adopted in the 80s at a time when the city of Austin had about 350,000 residents. The LDC has been amended a jillion times since then on a piecemeal basis, bit by bit, and the comprehensive revision of the LDC seeks to adopt an entirely new code, not piecemeal changes bit by bit, but have a whole entire new one to address Austin as a 21st century city and looking forward as it moves ahead. And when I say comprehensive, I don't just mean that it's going to cover the whole entire city, although it will do that. It will affect virtually every square inch of our city. But when I say comprehensive, what I mean is that the changes to be implemented in the LDC revision apply as a categorical matter. They apply uniformly, north to south to east to west within the city, across districts, across boundaries, across neighborhoods. They are implemented by text, not by map, to ensure that they apply equally everywhere throughout the city. And in the booklet that I handed you earlier, tab number 2 in the booklet is a zone conversion table. Mr. Becker's exhibit had a piece of this, but I'd like to talk a little bit more about it.
Let me just stop you for a second and ask you, so.
Yes.
It is true then that the new Title 23 will be adopted and the old Title 25 will be repealed.
It will not be repealed. It'll live there for various reasons not germane to the issue before you today. It will be superseded by Title 23, but Title 25 will sit there as a kind of as a zombie. It will not be formally repealed.
I'm not sure I understand the difference between superseding it and repealing it.
The new provisions of Title 23 will control. They will prevail and control and be an entirely new land development code. Title 25 will not be repealed completely, because if we repeal it completely, that will wreak havoc for grandfathering purposes. So it will continue to exist to the extent that there will need to be that there may be reference back to it for grandfathering purposes, given how state grandfathering law works, but it will not be the applicable or controlling land development code or its subset, the zoning code, for the city on a going forward basis once it's adopted. But the status of repeal or not repeal doesn't impact what's happening here before this court. But with the zone conversion table, it demonstrates that the classification changes in zoning, they apply everywhere in the city uniformly. If you look at this tab 2, the zone conversion table, page 5 of this zone conversion table explains that this, the city's going to prepare a map, a zoning map, for the convenience of people, because it's a lot easier to find your property on a map than to go through the conversion table. But to the extent there is a conflict, the zone conversion table controls over the map that's going to be adopted. And the changes that are going to happen to zoning in the city do not impact any given property or area or district or neighborhood any different from any other property anywhere in the city. So if you look at these, Mr. Becker referred to, say, the SF5, every SF5 in the whole entire city of Austin will become an R4. Each and every one, whether it's in Clarksville or Hyde Park or Dove Springs or Circle C or Northwest Hills or wherever it is, every SF5 will become an R4. That will change its uses.
And what the graph that Mr. Becker handed me shows is that the SF5 now has something under 20 units per acre, and the new R4 will have something in the neighborhood of 70 units per acre.
Yes, Your Honor. Well, I don't.
So it is a substantial change. Your point is simply that it's a change all over the city and not just to one part of the city.
Precisely correct, Your Honor. Each and every SF5 property in the city is treated exactly the same as every other SF5 property within the city.
So whether it's in central Austin or in the suburbs, if it's within the city, it will go up to 70 units per acre.
Whatever R4 is. And whatever it is, it applies uniformly across all neighborhoods, across all boundaries. And the reason that's significant for the purposes of the issue you are deciding here today, Your Honor, is that no given property within the city is uniquely affected. All of us, every SF1, every SF5, every SF4, each and every one of those properties is going to have the same conversion rules apply.
Why does that matter? It may bother some people more than others. It may, people who are in one part of town may be more concerned about it than others.
Here's why it matters, Your Honor. Because the individual written notice and the protest provisions in the statute exist to provide procedural protections for properties who will be uniquely impacted by zoning changes. And I'm going to skip ahead and I'm going to talk about that right now, because that's obviously something that you are.
So if you harm everyone the same, then nobody should get the protest?
Well, here's how it. The purpose of both the individual written notice and the protest provisions are to give procedural protections to those who are uniquely impacted. And that, I'm not making that up. The uniquely impacted, the uniquely affected properties is something, particularly regarding the protest provisions, the annotations of the Standard Act that Mr. Becker referred to, that Texas adopted back in the 1920s, refers to that, and the protest provisions. I'm sorry, I don't have a copy of this in my booklet, but this was attachment A to Mr. Becker's brief, to the plaintiff's brief, Exhibit A. Exhibit A to his brief is a copy of the
His original brief or his reply brief?
His original brief. And it's a copy of a model act, the Standard State Zoning Enabling Act, that was published by the Federal Department of Commerce by Secretary Herbert Hoover, who was Secretary of Commerce at the time. It cost a nickel, and it was published in 1926. And this model act is what was an iteration of this, is what Texas originally adopted in the late 20s as its zoning code. It was later amended in various ways. It was codified in the 80s, and it's the ancestor of what we have now as Chapter 211. And for purposes of this point that I want to make, that I want to emphasize, because this is critical, starting at the Adam and Eve here of Texas's zoning statute. Section 5 of the Model Act, the title of it is Changes. That's on page 7 of the booklet. Changes, and it talks about, and this has the protest provision, that if there are changes, then if so many people protest, then you've got the supermajority. But this booklet is annotated, and there are footnotes for what does change mean. What does changes mean? What does change mean? And this is discussed a lot. These annotations and this particular meaning of change is discussed a great deal in the expert report, the expert affidavit that the plaintiffs filed in this case. The David Brooks affidavit talks a lot about this footnote, this annotation. And what he says about changes and when there should be a 3/4 vote is he says that ordinary routine changes can be adopted by a majority vote of the local legislative body, but requiring a 3/4 vote in the event of a protest from a substantial portion of property owners whose interests are affected. Whose interests are affected. So from the very beginning, the protest provision has focused on who are the property owners, what are the properties whose interests are affected. Let's give them extra procedural protections. So that lives in the Standard Act. That same concept, fast forward to a Texas case directly on point, the City of Frisco case, FLCT versus City of Frisco. In that case, we've got a copy of it at tab 8 of the booklet. So in that case, the City of Frisco adopted a zoning change. Mr. Becker said, oh, it's not really a zoning change because it's just requiring a distance from how far from schools, hospitals, churches can you not sell alcohol. Well, what zoning is regulating the use of land. The use of land. That's what kind of buildings can be on there. What can be the use of the buildings? Can it be a home? Can it be a store? Can it be an office building? Can it be a factory? The use of land is zoning. So a regulation that says you may not use your land to sell alcohol if it is within so many feet of a church, a school, or a hospital, that's zoning. So the City of Frisco adopted a new zoning act, and this amended their existing zoning. It wasn't initial zoning. They amended their existing zoning to adopt this citywide rule that said, wherever you are, whatever kind of business or home or property or whatever you have, you cannot make this use of it. And that applied citywide, and it didn't affect one given area. It applied equally all across the city, across boundaries, across districts, across neighborhoods. And the city had to determine, the court had to determine whether or not the individual notice provision in Chapter 211 applied. Starting at page 19 of that opinion, there's the discussion starts there, where the court analyzed the individual written notice provision. And they said, accordingly, we will consider the proper construction of the term zoning classification as it is used in 211.007C. But then if you follow along, how did the court analyze it? And this is what makes this case, I think, so significant and so consistent in the chain of analysis I'm going to be talking about. The court first quoted in full 211.007. And then we're on to page 20, and they said, well, the individual written notice goes when you have a change in a zoning classification. What does classification mean? What does zoning classification mean? And then they discuss how, well, the Webster says this, the Code Construction Act says that, and.
Can I just stop you for a second?
Yes, Your
Because
Honor.
and maybe I'm looking at the wrong place, but back on page 7, what it said, it's the second full paragraph on page 7. It says that in August of 2009, the city council amended the zoning ordinance regarding alcohol sales, and it deleted the definition of beer and wine package sales and replaced it to say package sales, an establishment principally for the retail sale of alcoholic beverages, as defined in the Alcoholic Beverage Code as amended to the general public for off-premise consumption and rendering services that are incident to the sale of such goods. So it looks like what they're doing is changing the definition of package sales from beer and wine to include all alcohol.
That is the beginning portion of, okay, a couple of things, Your Honor. I think I might be looking at when I'm referring to page numbers, my page numbers may be different from yours, and I'm sorry about that. But if you look at, so let's talk about the page numbers of the opinion, the Southwest 3rd pagination. There's a lot of background, and this was amended, and that was amended, and this was amended. But then ultimately, where the horse is buried is if you look at 246, jump site 246. Then there's a paragraph that begins on October 23rd, 2012.
Yes.
That's the operative ordinance. That's an ordinance that's adopted by the city that amended their city code and added a paragraph prohibiting the sale of alcoholic beverages within 300 feet of a church, school, or public hospital.
But there is a phrase set out by dashes that say, that sentence says, they enacted a new ordinance which amended chapter 10 of the city code, not the city's zoning ordinance, by adding a paragraph prohibiting the sale of alcoholic beverages within 300 feet of a church, school, or public hospital.
Yes, Your Honor, but what that ordinance did, it was in a different place in the city code, but what it did is regulate use of land. What it did was zone. It amended zoning. The city did it in a goofball way in that it was elsewhere in the city code, but substantively it was a zoning amendment, a zoning change, and that is what the Fort Worth Court of Appeal was analyzing. This was a change in zoning because it restricted the use that people could make of their property, and so let's analyze whether or not the zoning regulations, the written notice provisions apply. And then there's a bunch of discussion of other, there were a bunch of challenges pleaded the jurisdiction, this and that, but the substance of our issue, of our 211.007 issue, starts at page 261 of the opinion, with a heading that says B, Local Government Code, Chapter 211. Okay, and so what the court did is analyze Chapter 211 in order to decide whether this change in zoning came within the individual written notice provisions of Chapter 211. The court tracked through 211 as a whole. They start out by quoting 211.007 in its entirety. Then on page 262, 263, they look at, they start looking at the other provisions of Chapter 211. They quote in full 211.005, which has regulations regarding zoning districts. Then it goes on to 211.006, which has the initial zoning provision and the protest provision. They quote those in full. And then at the very top of page 264, they talk about, okay, now that we've looked at this thing as a whole, the statute as a whole, what does it mean? And they say the context of these similar statutes, that all of these are of a sort, indicates that the legislature intended that if a city, either through its zoning commission or city government, wishes to consider a zoning district or boundary change to a discrete piece of property, it is to ensure that owners of surrounding properties that would be affected by the change have notice and an opportunity to participate in any hearing regarding that change. In other words, the individual written notice provision is designed to provide a protection to those who will be uniquely affected. That they go on to, they cite a few cases in a few other states and say the same thing happens in other states. Individual property owner notice statutes are not applicable to general, broad zoning regulation changes, such as the enactment of a recodification of a zoning ordinance. And then they explain at the bottom, further on in 264, a general purpose of notice provisions in the zoning context is to protect individual property owners from municipal overreaching. So they analyze,
Where are you on that?
that was in the middle of a paragraph.
Oh, I
that-
see it, I see it.
But so what the court reasoned is that they looked to, in order to decide the scope of the individual written notice provision, 211.007C, in order to determine the scope, they looked to its purpose. And its purpose was to provide notice to property owners who would be uniquely affected. And because the ordinance at issue here, which applied across boundaries, citywide, in every district, in every neighborhood, the thing about not being able to sell alcohol within so many feet of a church or a school, because that didn't uniquely affect any property owner, that wasn't a change, a zoning change that came within the scope of the individual written notice provision. And that is completely consistent with the annotations of the Standard Act back in the 20s that talked about it is a protection for property owners whose interests are affected. So
Well, and so your argument essentially is if only a relatively small number of property owners are impacted, then they have the right to notice and to protest. But if a huge number of property owners are affected, then they don't have the same right.
Well, Your Honor, it's uniquely affected. Are individual properties uniquely affected in some way that is different from the city as a whole? And this concept of uniquely affected properties coming within both the notice and the protest provisions is also reflected in the definitive treatise regarding Texas municipal zoning law, and that is the Mixon Treatise. And we've got a copy at tab 7 of the booklet. We've got a copy of Chapter 7 of Mixon, which is the chapter that governs amendments, that discusses amendments of existing ordinances. And this is Mixon is cited by both expert affidavits that were filed in this case. Our expert, Brenda McDonald, and also the plaintiff's expert, David Brooks, cite to Mixon as the definitive treatise. And Mixon discusses the difference between a comprehensive revision and what he calls spot zoning or individual tract zoning. And specifically explained, and this is something that I wanted to talk about, the item 2, skipping back a little bit. This comprehensive revision is similar to initial zoning because what it reflects is broad citywide policy considerations for the governing body of the city. Unlike individual tract zoning, that's going to depend on the particular characteristics of this piece of property or the use of the particular neighborhood there, this LDC revision represents and reflects general community policies. And also, Mixon explains that for comprehensive revisions like this, they are generally very widely publicized, as evidenced by the TV cameras here and the number of people who have expressed an interest in coming to these proceedings. Unlike an individual tract zoning where a person may not know it's happening, something like this, and Mixon explained that treating it in a different way, treating it more like initial zoning rather than individual tract zoning makes sense for a couple of reasons.
Let me just stop you and say,
Yes, sir.
if that's what the legislature intended, why didn't they have one provision that applied to the adoption of original zoning ordinances and the adoption of comprehensive revisions to the zoning code, land development code, and then one for what you call spot zoning? Instead, the first part only applies to adoption of original zoning ordinances.
Well, you're right, Your Honor. The statute doesn't specify the difference between the two. There's a comprehensive, there's the initial zoning, and then there's the individual written zoning. But I'll note a couple of things. First of all, the individual written zoning, that wasn't part of the Standard Act in the 20s. That wasn't adopted until the very late 1940s. Up until that time, there was no individual written notice at all. There was no provision for that at all. And the individuals whose, a property at the end of the block was going to get rezoned, there was something in the paper. And so when the legislature adopted the individual written zoning, the individual written notice provision, what they did was address a circumstance that happens a lot. The city of Austin has about 150 per year individual zoning cases where most often it's the property owner who applies for a zoning change because they want to build something or make some use, have a particular type of business that the existing zoning doesn't allow them to do. So the property owner will apply to the city, let me change my zoning. In an individual zoning case like that, there are about 150 a year. Those happen all the time, and that's what 211.07C responds to. Something like this doesn't happen all the time, a comprehensive revision, but it has been happening more often. And Your Honor, if you look at tab number 6 of our booklet, that's the affidavit of Brenda McDonald. Brenda McDonald is one of the authors of Mixon. She's one of the current authors of Mixon. She is an expert regarding land use regulation in the state, and she is both advises cities as outside counsel and also serves as city attorney for a number of smaller cities. And she explains at paragraph 13 of her affidavit, she explains that a number of Texas cities in recent years have done what the city of Austin is doing right now, have undertaken comprehensive revisions of their land development codes, including their zoning codes. She lists a bunch of them there, including some right in our area: Round Rock, San Marcos, Marble Falls, also Denton, Frisco, and all of those cities are following the exact procedures that the city of Austin is following, which are the procedures that Mixon says are appropriate here, which are the same procedures that the FLCT case said are appropriate here.
So apparently there's nobody suing them.
Well, Your Honor, the city of Frisco is the city that was at issue in the FLCT case.
Right, but that wasn't a comprehensive revision of their entire land development code. That had to do with...
Not in that case, Your Honor, but the published notice, not individual notice, and then not having protest rights at the back end that is how all of these cities have handled the comprehensive revisions, and that's also how Mixon says it's appropriate to handle it, and that's also consistent with the FLCT case. And also, Your Honor,
well, I would be much happier if somebody had sued them and there were a law that I was required to follow on that. But apparently none of those have made their way to either the Austin Court of Appeals or the Texas Supreme Court.
None of those have, Your Honor. But what I'd like to do is talk a little bit about explain some of the practicalities of how does this work? How does notice look? What do protests look like? So you can see in context, here's what this actually means, and here's the impact. And the reason I want to make this point is I'm not going to say you need to cut the city slack because it's a lot of trouble. The point I want to make in demonstrating this to you is I hope that you will see that applying the individual written notice and protest provisions to a comprehensive revision of the Land Development Code would be absurd, and that indicates exactly why those provisions are not applicable to a process like this. So starting out, if you turn to tab 3 of the booklet, tab 3 of the booklet is a real notice. This is a real notice for a real individual zoning case that the city sent out. This is joint exhibit number 51. And you can see that it's several pages long. It identifies the property. It says, it tells you what is the existing zoning, SF2, what's the proposed change zoning, SF3, and just as an aside, Your Honor, any written notice has to give notice of what the change is going to be. We're going to change to, in this notice, we're going to change to SF3. And both city code and state law provide that the ultimate zoning, even if the city council or the zoning commission amend things and say, no, we don't want to do that, let's amend it, they cannot adopt a zoning classification that is more intensive than the one that's given in the notice. And so here in this instance, if the city had sent individual written notice of the LDC revision back before the Planning Commission meeting in October, the city would have had to identify for each and every property in the city what the proposed new zoning was going to be.
Isn't that what the chart does?
No, well, a couple of things, Your Honor. Would have had to give that notice back in October. This chart is the current iteration, is the current version after the Planning Commission did its work and made amendments. City Council on first reading did its work, made amendments. The City Council on second reading did its work, made amendments. But if the individual written notice provisions applied, we would have had to have included the ultimate, and these can still change, Your Honor. That's part of the ripeness question. These can all still change. That's why tab 2, the zoning conversion table says draft, has a watermark that says draft, because these things are still being worked out. But if the individual written notice provision applied, we would have had to identify for each property, not all SF5s will be whatever, not all SF5s will be R4s, but 1406 Hartford Road will be whatever. And it would have to do that, and even though you had Planning Commission and City Council 1 and City Council 2 and City Council 3 and all the amendments, couldn't change it. Couldn't change it
and that
or
is,
start over.
And that is apparently the case if you had chosen to just rezone one lot or one of the lots on one street or in one subdivision. In that case, if they changed it, you'd have to send a new notice.
Yes, Your Honor, but that's a difference between one lot and a comprehensive citywide, because the comprehensive citywide revision is, the purpose of it is implementing community-wide policies.
And
That's
that's
sometimes
what
our intention with each other.
Let me just say that's why I'm having a hard time understanding why something that affects hundreds of thousands of people instead of a small handful of people doesn't deserve the same level of notice and protest.
Let me move. Here's why it's appropriate to treat it this way. I'm going to skip back, and then I want to come back and I want to talk about some detail about the notice and protest, because I think it's important for the court to have an appreciation of the absurd results if we do that. but I'm going to skip back to this bottom one, because here's where I want to talk about policy. Why is it appropriate, you said? Why is it appropriate that individual notice and protest rights are not applicable here? It is because this is a legislative process that the city is engaged in. The LDC revision reflects broad policy decisions by the city council that are applied to the city as a whole. It is not an adjudicative process dependent on the particular facts of any one particular property. There are no individual properties or property owners who will be uniquely affected as distinct from the whole entire city as a whole. And I want to do the same thing Mr. Becker did and refer the court, because I think they're important, to the amicus briefs filed in this case. There were amicus briefs filed on both sides. Several community organizations filed in support of the plaintiffs, several community organizations, including Austin Habitat for Humanity, including Environmental Texas, filed in support of the process, the procedures that the city is following. And those community organizations, they represent a wide variety of interests and concerns, and they present different views regarding whether they think that the net result of the LDC revision is a good idea or a bad idea for the city of Austin. But what is most important and significant about that is when they bring to the court and express, I think it's a good idea for this reason, or I think it's a bad idea for this reason. Those differing opinions reflect their considered opinions regarding the best way to address a number of significant issues that the city faces. Housing affordability, displacement of traditional communities of color, environmental concerns, transportation concerns. And adopting a comprehensive plan like the LDC revision reflects the city council's analysis and determination of the best way to balance all those issues, many of which are in tension with each other. And that is a quintessential legislative act. And none of us are left out of that. And all of us can be heard because democracy, because all of us can sign up and go to the city council meetings and the planning commission meeting. All of us can lobby our city council members. All of us can exercise our ability to be heard in this legislative process. And the city council will take all of that into consideration as the elected governing body of this city. They will take into consideration all of that input from their constituents, as many of them are, as all of them are, I dare say, and make their decision. All of us have the opportunity to come in and be heard, but what we don't have, what you and I and all of us don't have, is a veto over the legislative process of the city of Austin. And that's why.
Well, and let me just say this, playing devil's advocate. So what you're saying is, if I as an individual property owner have some rezoning that's just me or just a small number of people, and I go in and protest, then that forces the city council to approve the change by 3/4 vote. But if I as a property owner, along with hundreds of thousands of other property owners around the city, don't like the zoning change, I can't force a 3/4 vote of the city council.
That's correct.
And I guess I need to understand why you think the law supports that position and why you think the policy of that is.
Well, Your Honor, the statute is what the statute is. And this issue of application of the individual written notice and the protest rights, whether they apply or not, stands or falls on whether the legislature provided for that in Chapter 211. But if we look at Chapter 211, if we look at its history, the Standard Act says the notice provisions are meant for those who are uniquely affected. We look at the Texas case, the only Texas case that is analyzed specifically, what do zoning changes in the context of 211 mean? They said the purpose of that is to protect uniquely affected properties, and it has no application to across zoning changes that apply across neighborhoods, across boundaries. We look at Mixon, which is the definitive treatise, says the same thing. You may think this is a dumb statute. You may think it strikes the right balance. You may think it's good policy, bad policy. But the fact is, that's what it does. That's what it's, the purpose of the individual written notice and protest rights is to protect individual properties or discrete areas. And that's how they apply here. And the protection for all of us is through our city council, is through our elected officials.
Let me just stop you for a minute, because you're calling it individual written notice and individual protest rights, but that's not what the statute calls it.
You're right. They don't call it individual written notice rights. I use that as a shorthand. The individual notice, the notice rights of 21.006 C and 211.007 C notice, the notice rights. But the statute sets those out, and its history and the way it has been construed by the only Texas court to address what is a change in zoning for purposes of the scope of the 211.007 C notice provision. There's only one case that has analyzed this, and that's the FLCT versus City of Frisco case. Has analyzed precisely what's the scope of 211.007 C, and the court said the scope is determined by the purpose, and the purpose is where is to protect property and property owners who are uniquely affected. And Your Honor, before I run through all my time, I do want to walk through. Here's how notice works. Here's how protests work, and here's how they would be. It would lead to absurd results.
And I think you did a pretty good job of that in your briefing, so.
Thank you, Your Honor. I'm just gonna, may I approach?
You may.
So this demonstrative is in the brief, and it shows, here's how notice works. So the green circle is the buffer zone that for the state statute is 200 feet. For city code, under the city code, it's 500 feet. So the area of who the city actually has to send notice to for, if individual written notice is required, the scope of people who the city has to notice is greater than under state law. Now, that's not a, I'm just letting you know. So for the black house in the middle, it has a 200-foot green buffer around it, and it captures a bunch of...
The planning commission and the city council, then they could just do the notice by publication.
Yes, Your Honor. If the city, that provision, so that's the 1985 amendment. That's D. D as in dog. 211.007 D as in dog is the 1985 amendment.
Exactly.
And there's nothing in that 95 amendment that says comprehensive. There's nothing about it that makes it apply to a comprehensive revision. That word comprehensive isn't in there.
The word individual wasn't in there.
That's true. The word individual is not anywhere, even in the individual zoning provision of 211.007C. What Mixon says is whatever was the purpose in the mind's eye of the legislature when they adopted that 1985 amendment, it is arguably that one. It could apply even to an individual zoning case under its language.
It doesn't specify.
It doesn't specify at all. So that doesn't speak at all to what we're talking about do the regular individual zoning provisions and protest provisions of Chapter 211 apply. That is not an exception that the legislature put in for comprehensive. That's not a repeal. as to comprehensive rezoning. That doesn't address comprehensive rezoning, left, right, or center. That is
It's just
an
an
oddity.
alternative notice provision.
It is an oddity that allows basically a city to secede from the regular zoning provisions. We're not asking to have that one apply. It doesn't, we're not required for it to apply. Mixon explains that before or after, that the 1985 provision doesn't appear to change the landscape at all, and that under the provisions without that amendment even, without it, the Enabling Act does not require individual notice to particular landowners, and the governing body can adopt it by a simple majority, even if 20% protest. In other words, the protest rights do not apply. And so that, and it says courts can and should construe it that way. So the existence of the 1985 amendment doesn't change things. That's just a quote from this. So what I put up here is a demonstrative, and this is in the record. It is Defendant's Exhibit, I believe, 4, and it's in that big honkin' notebook I gave you earlier in a sleeve. It's this big blow up. It's folded up and it's in a plastic sleeve. And so just like this small demonstrative shows kind of overlapping circles of notice surrounding, creating a buffer zone around each property that's being rezoned. This reflects, so if the individual notice provisions apply to the LDC revision, the whole entire city of Austin would be covered with overlapping circles of required notice, because essentially every property in the city has a zoning change of some variety, and so the buffer around it would be entitled to individual written notice if that applies. So just to illustrate what that is, we just took one area of the city. This is Manor Road. The red line is Manor Road, and this red line is a segment, it's 3/4 of a mile long. And it runs from Rogge Lane up to Northeast Drive there. And the blue properties are properties that front Manor Road. And the dotted lines reflect the 200-foot buffer zone around each of those properties that front Manor Road. So there are 50 properties, 50 blue properties. And each one of those, within their 200-foot buffer, captures multiple other properties who would be entitled to the notice, the statutory notice under the statute. And the number of properties within the buffer zone varies, starting with as few as 10 or as many as 36, for a grand total of 1,058. And that's one segment of Manor Road, 3/4 of a mile long. So just picture what it would entail. And so Mr. Becker said earlier that the city could just send one notice. And it just sends notice, it just did that, sent one notice with the utilities. It's real easy, and that's what the city has done in the past regarding the neighborhood plans. And I'd like to talk a little bit about that, because that's not entirely accurate. Your Honor, may I approach?
Yes.
So I'm going to hand you what, this is Joint Exhibit number 56. It says it on the bottom there. And this is the notice, this is the actual notice that the city sent for one of the neighborhood plan adoptions. This one involves St. John and Coronado Hills, but the same process applies for all of the different neighborhood plans. So the neighborhood plans, when the city adopts a neighborhood plan, there are two sets of things that happen, basically. Is within the boundaries. So if you flip back to, I think a good way to do this, flip back to page 15, which is attachment number 5. Attachment 5 to this notice. And you can see on the left hand, there's a map that shows the boundaries of the the boundaries of the neighborhood plan, but then within it, there are certain specific tracts that are that are in blue that are numbered. And then on the facing page, the individual tracts are identified, and there's a listing of the existing zoning and the proposed new zoning. And there's a similar chart for the St. John neighborhood plan on page 7, which is attachment number 2, because remember this is the combined. So the neighborhood plans do two things. One is they adopt regulations that are going to apply covering the whole entire neighborhood area within the boundaries. But then in addition, there are some, within the neighborhood, there are some specific tracts that are going to be uniquely affected, that are going to have different zoning changes just as to those particular properties. So through these notices, what the city did was give notice of, hey, you're in this neighborhood, we're going to rezone, we're going to adopt a neighborhood plan that is going to have comprehensive revisions, but then also, as to these individual tracts, we are going to do specific rezoning. And then the city recognized protest rights and required supermajority if there were qualifying protests regarding any of the specific tracts that were being rezoned. In other words, the buffer zone around, some of those had to get passed by a supermajority. If the buffer zone, say, around tract 18, if that, within that buffer zone there was more than, owners of more than 20% of the area protested, then the city council would pass that by supermajority. Now, as far as the neighborhood plan as a whole, that's a discrete area. And so the city treated that and as a discrete area for purposes of giving written notice, and the city would have recognized protest rights, except that, what's the denominator? What's the denominator? If you're trying to figure out 20% of the neighborhood plan for purposes of determining whether or not there's a qualifying protest, the denominator is the whole entire boundary. And in no instance did any neighborhood plan have 20% of the area of the whole neighborhood plan protest. So as to some individual tracts, those had to pass by a supermajority. As to unprotested tracts, simple majority. As to the neighborhood plan as a whole, simple majority. And that is exactly what the city is doing regarding the LDC revision. There are, and I think the Brenda McDonald affidavit discusses this to some extent. I believe there are going to be certain tracts within the city that are truly going to have zoning changes. Not just the conversions that apply uniformly to everybody, but there will be some individual tracts where the actual zoning is going to be changed. And as to those individual tracts, the city will send individual notice to everyone in the buffer zone, and the city will recognize protest rights, and a supermajority will be required to adopt those zoning changes if there is a qualifying protest. And let me talk real quick about what does a protest entail. Some of this is discussed in our brief, but Your Honor, if you look at tab number 4 in the booklet, tab 4 shows, it reflects the actual process that the city goes through to analyze whether or not there is a qualifying protest for a zoning change. And when I say qualifying protest, what I mean is 20% or more, the owners of 20% or more of the area within the buffer zone. So the way we came up, this is a demonstrative exhibit, it's defendant's exhibit number 3, and we created this demonstrative exhibit for purposes of this litigation. But the way we created it is that the city stacker, who actually does this, the person who does this calculation sat down and went through each step and took a screenshot of here's what I do, this step 1, and step 2, and step 3, and step 4. And it is complicated because it requires use of a geodatabase, because you're calculating what is the square footage of the 200-foot buffer zone. How do you allocate rights of ways? What if the 200-foot buffer zone only cuts the corner? For example, here, this buffer zone, a buffer zone, if it just nicks a corner of a property, that property owner is entitled to get notice. But when it comes time to calculate the protest and whether the owners of 20% of the affected property, only that corner is included in the square footage, because it really is what's included in the area, in the 200-foot buffer zone. And that's why it's a complicated process. And it requires, they use the TCAD database to ensure that they've got the correct owners. They use the geodatabase to get the square footage. They go through all these steps. Then they have to allocate the right-of-way, because streets, how do you count streets? Well, the way you count it is you're entitled to half of the right-of-way. So let's say when you're looking at this buffer zone, half of Wheeless Lane gets allocated to this property, and across the street gets allocated to that property, and across the street, for purposes of the calculation. And you have to go through all of those steps, and then after you do that, then on the geodatabase you have to click to take out what is outside the buffer zone. And that process, to take, here are the protests, let me calculate whether the 20% is met here. For each one property, it takes about an hour. So what we got 14,000 there, and if those 14,000, if they are similar to the ones that the plaintiffs file, they say, I protest not only as to my property, but as to any other property that is within 200 feet of my property. And so 14,000, including what additional number as to each of those are within the 200 feet of their property, and do that calculation, that hour for each one. And then if you flip to tab number 5, tab number 5 is the net product of what you get after you've gone through that hour process and done that calculation to determine. Tab 5 is the finished product of a petition. And we have 3 examples just to show you what does it look like. So on the first one, there was 100% of protest, and so it reflects that the entire area is protested. Then the second one shows how sometimes you can get more complicating factors. For example, railroad right-of-ways, you have to subtract those because they are excluded by statute from the area to be calculated. So you have to take that out. And then you see the table on the right-hand side, and there's a similar table on the third one that has all of the different properties that are within the 200-foot buffer. We've redacted the names of the owners for purposes of the record here. Whether or not they submitted a signed protest, what is their square footage, what percentage of the whole area their square footage is, and then it adds it up. 37.8% have protests. Okay, that would be a valid protest. On the one below, the third one, it's the same. It shows who are the properties, did they protest or not, what's the different square footage, what percentages. 15.5, that would not be a valid protest because it didn't make the 20%. And so that's how notice and protests actually work. And if they apply to the LDC revision, how would they apply? It's absurd, the resources that would go, the time that would go regarding the, both the sending of the notice and the calculation of the protest. And then there's another question, what's the appropriate denominator? Because the LDC revision applies as a whole. It applies to the city as a whole. If I protest as to my property and all the ones near me, there isn't anything about the LDC that singles out my property. Does that mean that if I protest mine, then the city council has to have a supermajority for the whole entire LDC revision as a whole? With not only is zoning, does the zoning cover the whole city, but the LDC revision, look at it. I mean, it covers a lot of different things, not just zoning, and the zoning that it does cover is comprehensive and citywide. How does the protest provision apply to this animal? The fact that there is no answer to that, no reasonable answer to that, is a further indication it's a square peg. It doesn't fit. The written individual notice provisions and the protest provisions both exist for the same good, healthy, hale reason, and that is to protect individual properties, individual property owners who are going to be uniquely affected by a zoning change. If my neighborhood, if my block is going to have a zoning change, I'm entitled to notice so that, because I'm going to be affected uniquely, different from you or you or you. But where you have a legislative act that covers the city as a whole, and I cannot emphasize enough the fundamental nature of this as a legislative act and not an adjudicative act. Individual zoning decisions are adjudicative. If I want to change, have a business on what is now the property that has my house, my neighbors are going to be uniquely affected, and the Planning Commission and City Council's decision is going to focus on the particulars of my property and those facts. They're going to adjudicate whether or not that's a good idea. That's not what's happening here in this LDC revision. This reflects a comprehensive policy determination, a balancing of all of those many competing concerns that all of us have, that the many amicus filings have brought forward to this court. The LDC revision involves a balancing and consideration of a lot of different public factors, a lot of challenges that our city faces. Many of those, as I said before, many of those considerations are in tension with one another. And it is an absolutely appropriate function for the elected governing body of our city to make those determinations in the context of the legislative process. The legislative process in itself provides due process to all of us. We know it's there. We can speak out. We can be heard. We can exercise our democratic rights. We can petition our government. No, don't adopt that one. Make amendments on third reading the way they have on the first reading and on the second reading. At the back end, if we don't like it, we can vote them out. But that is the legislative process, that is representative democracy, and the application of the individual written notice and protest rights is a square peg. It doesn't fit. And I urge the court to construe the statute consistent with the annotations in the Standard Act, consistent with FLCT, consistent with Nixon, consistent with a dozen Texas cities, with the only information we have regarding how Texas cities are actually construing this statute in practice as they adopt comprehensive revisions just like this. We urge you to follow that path and deny application of the statute to the comprehensive revision of the Land Development Code.
Thank you, Your Honor. I don't have too much, just a few things, I think. Well, once again, the city says, can't give individual notice, it's too hard. That's, I
I
guess.
think absurd is the word.
Okay, well, that's hotly contested, either that it's too hard or that it's absurd. And even if you want to hold the opinion that it's too hard and it's absurd, it's required by the statute and by the plain language of the statute. Therefore, if they go that route, that's what they have to do. They don't have to go that route. They can go the 211-007D route and have a joint meeting. Their expert, who is well known, Mr. Mixon, himself says, and we quote it in our brief, that 211-07D does apply to comprehensive revisions. And so they can do that. As far as the other conclusions that they reach, we have a pretty renowned expert ourselves, David Brooks. His affidavit analyzing Nixon and the law comes to quite different conclusions from his counterpart that's cited by the city. I also want to mention the city's brief quotes from Nixon, which is fine, but there's in the same section 7.02, which is on this blow up and which is read to you, which is relevant. Nixon in that same section has a phrase that is not on their blow up. He says, logically, the Enabling Act could be interpreted to require only community-wide notice by publication for such revisions. And he's talking about the kind of notice the city gave, not a joint meeting. The very next sentence from Nixon is, quote, comprehensive revisions can with equal logic be viewed as reclassifications in that they will reclassify some tracts. Landowners in reclassified areas and within 200 feet therefrom can reasonably claim that reclassifications resulting from comprehensive revisions are ineffective unless the zoning commission gives specific notice by mail and the governing body adopts by a 3/4 majority in the event of protest. So it's not just one-sided, there's no other view. This is the way that I'm sure the law is, not even from Nixon. He himself says that the argument we're making is reasonable. We could reasonably claim it, and we did. With respect to the Frisco case, which is all they got, once again, it involves the sale of alcohol around schools. It only applies to the citywide revision. It doesn't name any particular properties. It's general applicability rather than to any. It's not an ordinance that names any particular statute, and that's all it does. Whereas our changes, they change the density, the height, the setback requirements, etc., for every property in Austin, or nearly every property in Austin. So, and if you look at the charts we have attached to our reply brief, what you see is the huge changes. And it's not just one for everybody. As Weber's arguing, well, these are just across the board changes. They don't affect particular people uniquely. Well, if you look at the chart we looked at before, you'll see that 4 different people can be zoned single family, and even single family 1, let's say. But they're not all being rezoned the same. They're being rezoned differently. And we have that set out in the brief. And you know, I have what I describe as a tearful note from one of my clients out there. You know, what are they talking about that we're not unique? We're all uniquely affected. And the changes on this are large, and they're different for people who are fairly similarly situated. There's no comparable equivalence. People who are zoned single family have a whole range of rezoning that might be that they're going to be subject to. So it's like I think I heard you say before, if the city's position is that, well, if they're rezoning 95% of the properties individually, well, that's adjudicative, and so we have to give notice, and there has to be protest. But if we rezone 100% across the board, well, we don't. Well, if you want to talk about an absurd result, I think that's one. The other problem with that argument is many of the cases say all zoning is legislative, regardless. And so the city wants to draw a distinction between legislative and adjudicative. The adjudicative part being the fact-based part. This is just changes to the text. Okay, it's not just changes to the text. It's changes to the maps as well. But to take your argument and run with it for just a minute, the transcripts of the city council meetings on second and third readings are part of this record. And if you look at those transcripts, you see all kinds of discussions and references to specific properties and to specific areas. The city council members are elected representatives. That's the definition of a politician, I think. It's their job to be responsive to those whom they represent. And as you know, we have districts in the city of Austin. So you don't think those council members on that dais are talking about things they want to change that are affecting their own constituents uniquely, in their opinion? They do. Those discussions are tremendously fact-based, adjudicative. That's just a label. The truth is that under the law, they're all legislative, and all of those changes should be subject to the notice and the protest provisions unless they go the route of a joint meeting. Finally, I have I don't know how many times I've read the 4 subsections of the local government code that apply. I'm sure it's 100. And the first time I read it, I thought, this can't be right, what the city is doing. It's the plain language of the statute. And it talks about repeal. And I understand, honestly, I didn't really follow Ms. Weber's argument about why this is not a repeal. To me, it's a repeal as a matter of law. And there was something about, well, we can't really repeal it because we need to grandfather certain things. You can grandfather people based on a prior statute, even though it's repealed. I think it happens all the time. So it's not necessary. She's making that argument because if it's a repeal, boom, she's under Section 211. An amendment, a repeal, or other change. So she wants to say it's not a repeal. It's a repeal by implication. But even if it weren't, or other change of a regulation or boundary, the new land development code is chock full of thousands of changes to regulations and to boundaries. So, like I say, I keep reading it and I keep not saying it, seeing it any way except the way that we're arguing it. So I would ask the court to uphold our position, make the city do it right.
Thank you, Mr. Becker. Ms. Weber, do you have anything you want to add?
No, not really, Your Honor. I think I've said one language thing. I probably should have used the word quasi-judicial rather than adjudicative to describe what the city council does regarding an individual zoning case, but legislative is what it's doing here regarding the land development code.
Thank you. All right. Well, I really appreciate all the work that y'all have both put into the briefing and also the excellent arguments you both made. I do, when I see this much work go into a case, and I know that I haven't looked at every page yet, I do feel a responsibility to go back and review what you provided to me. And so I will do that. So I'm taking the matter under advisement. I will move as quickly as I can, although I'll tell you, I've got a number of things ahead of y'all on my under advisement list, and I'll just get to it as quickly as I can.
Can I ask you one question, Your Honor?
Yes, sir.
The only thing I think maybe that you might want some more briefing on is ripeness. We haven't briefed that at all, and I don't want to throw more repetitive stuff at you, but I would like to get you a brief on that as quickly as I can. I don't know, is Monday good, or?
That's fine.
Okay.
And I will say that it's really only mentioned in passing in the city's briefing, so I don't know. My impression is they don't want me to rule based on that, and I think the arguments that you made here about rightness are well taken. So unless the city wants to go back and argue that that's really should be the basis of my ruling, which I don't see how you can argue, then I don't know that we need a whole lot more on that. So y'all might want to confer on that, and if you want to emphasize that, then I'm going to give you time to do that as well.
I don't anticipate